All right, good morning, ladies and gentlemen, and welcome. It is a pleasure to have the opportunity to be back with you again. I am Chief Alaric Fox of the Enfield Police Department, and along with Karen Foley O'Connor, we have the great pleasure of co-chairing this Police Response to Crimes of Family Violence Model Policy Subcommittee. I thank everyone here for their attendance this morning. We will get through the first part of the agenda. We are looking forward to a robust presentation on GPS monitoring, which we anticipate will occupy the majority of our morning together. As I mentioned a moment ago, Roman numeral 2, welcome and introduction of council members. My name is Alaric Fox. I represent the Chiefs of Police Association and am the Chief of Police in the Enfield Police Department. I'll begin with the individuals that are live in person in the room, and then we will certainly welcome members that join us virtually.
I'm Karen Foley O'Connor, CEO of the Network Against Domestic Abuse, serving North Central Connecticut, providing advocacy.
And perhaps we could continue to the left.
Hi, I'm Joe DeTuno. I'm the Director of Family Services, part of Connecticut's Judicial Branch.
Welcome, sir.
Good morning, Attorney John Delbar, Assistant Legal Counsel for the Office of the Chief Public Defender and the Public Defenders Commission. And I'm here attending on behalf of the Acting Chief Public Defender.
Thank you, sir.
Good morning, Captain Ryan Maynard, Connecticut State Police.
That exhausts the individuals that are live at the LOB. I know it's always sort of who's going to speak first, and then people pause and then speak over one another when we ask folks to introduce themselves via Zoom. But 5 years into working with Zoom, I haven't figured out a better way to do it. So it's a free-for-all, and I welcome each one of you to introduce yourselves and tell us who you are and who you represent.
I'll go first. It's Nancy Tyler, attorney and survivor representative appointed by CCADV.
Welcome.
Garrett LaJoy, complaint officer for the Office of the Victim Advocate. Good morning.
Good morning and welcome.
I'm Rosario Taron for Safe Connect, representing CCADV.
Fantastic. Thank you for joining us.
I'll go next. I'm Shauna Harrington, Director of Legal Advocacy at CCADV. Nice to see everyone.
Good morning. Good to see you.
Good morning, Andrea O'Connor, Umbrella Center for Domestic Violence Services. I supervise the court-based victim advocacy program in New Haven, Milford, and Derby.
Thank you. Pleasure to have you with us. And nobody stepped on anyone else. That was actually very well done. To the extent you folks rehearsed it ahead of time, we are very impressed. Thank you. I would enter the minutes of our last meeting, August 19th, 2025, had been provided both electronically prior to today and physically within the room. I would afford the group the opportunity to review those minutes if you have not already done so, and at whatever point anyone feels comfortable, assuming that occurs, I would entertain a motion to approve the minutes of August 19th, 2025, assuming no one wishes to offer any additions, corrections, or deletions.
I'm just going to abstain since it was not present.
Yes, sir. Thank you. I would entertain a motion if anyone wishes to so move.
Motion, Maynard.
Do I have a second?
I'll second.
All in favor signify by saying aye. Aye.
Aye.
Any nays?
I'll be abstaining. I wasn't present at the meeting. Thank you.
Noted on the abstention. Seeing that matter passes with the roll call vote, we will consider that passed. Moving on to Roman numeral 4, I will take the liberty of pausing for a moment and just setting this one up, and then we'll look forward to the presentations that have been prepared for us. As this subcommittee and its members know, we have been challenged, we have been charged, we have been tasked to attempt to do more than just work with the current policy and say, is it up to snuff? Is it appropriately reactive? We have been appropriately encouraged to consider if there are any places or any ways in which we can collectively look at domestic violence as a significant societal issue and seek to improve in a more proactive fashion law enforcement's the way in which law enforcement addresses these concerns. This has led to some preliminary discussions which have been productive, which have been worthwhile, and that have focused largely on how law enforcement receives, how law enforcement reacts to, and any further potential uses, if any, of the GPS monitoring program that is in effect, with an awareness that there are legal implications to some considerations, or to any consideration, perhaps I should say, of an expanded use, or the consideration of an expanded use on the GPS monitoring. So in just a moment, we will get there, but I will defer to see if my co-chair has anything that she should wish to add before we get to the substantive part of our time together this afternoon.
Thank you. So in our discussions in our last subcommittee meeting and in reviewing the current model policy, this GPS section definitely needs improvement and updates on, to date, we're now at fully, the entire state's participating. So we want to indicate that there's been some changes in the zones. So since we're going here, and as well, we've heard that there have been varying types of responses by law enforcement that we'd like to get kind of consistent across the state. So in that discussion, there were some people on the subcommittee that said, I really want to learn more about it. So what we've done is we had some discussions, but it turned a little different to try to give you the best picture. We're going to have Joe DeTuno from Family Relations talk about how a person gets put on the GPS, what those considerations are, how that happens. And then we're going to also talk about what an alert looks like to law enforcement and how they respond currently. And then we want to hear from the Family Violence Victim Advocate viewpoint of how they prepare their clients, survivors, for what that looks like and what different levels of participation they have. And then lastly, we would like Safe Connect representative to talk about Safe Connect's role, because they play a role as well in alerting, so that if a victim does get a lot of false alerts, if you will, or that they'll let the Family Violence Victim Advocate know. So I think the best thing to do is start with where it all starts, and that would be with Joe.
Okay, and please feel free to jump in, others that are speaking, because this is a pretty significant collaboration between Family Services, Family Violence Victim Advocate, prosecutor, judge, as we kind of address these cases in the criminal justice system. But for the Family Relations Counselor, first I want to say right now, actively as of yesterday, we have 311 defendants on alert notification GPS statewide. The vast majority of those individuals are usually housed in the 5 major courts, the largest courts that we have. We have 158 individuals that are held on bond with the condition of alert notification GPS, so that when that defendant makes bond, they'll be put on the program. In terms of victim participation, we have 313 victims currently participating, with 244 of those carrying a device with full participation. So 311 defendants, 244 victims carrying a device as we sit here today. Family Relations Counselors, we touch these types of cases at 6 different and distinct points. The first is pre-arraignment. So that's before a defendant goes before the judge at their initial court hearing or court proceeding. Family Relations counselors have a role. After the judge orders alert notification GPS, we have a role in terms of getting that defendant installed with the device, and the victim, if that person chooses to fully participate, get their equipment as well. Most importantly is our case management. So after a defendant is installed and in the community, Family Relations counselors have a role in case management. We provide compliance reports to the judge and prosecutor every time that person has a court continuance date. and we talked about their compliance. We have a role in reporting serious violations and non-compliance. And that could be at any time during the time a defendant is on the program. And then we have a role in program termination. So when a judge determines that the person no longer is going to be on the device, either because the case is disposed or just in terms of a request from an attorney or a self-represented individual, and they ask for to be taken off the program, we have a role there. So basically, you know, I always say this when I do introductions of the program. Family relations counselors with the victim advocates do the most of the heavy lifting in this program at a court level, and really reporting about that defendant as they move their way through their case. Before arraignment, a family relations counselor, there's a statute that really dictates what family relations counselors do in terms of installing a defendant or making that recommendation to the court. There's a statutory criteria. Our role is to go through our arraignment process, identify those individuals with violations of orders of protection or very serious domestic violence charges. We conduct a risk assessment, and then after those two things are completed and the victim is contacted with the help of a family violence victim advocate about what level of participation that person wants, either to have a device and have mobile zones or just a stationary zone alerts around that. We indicate to the court through the prosecutor which defendants meet the statutory criteria, and we let the judge know what level of participation the victim wishes to have. If a victim chooses to not participate, we let the judge know that as well. Shauna or Andrea, do you want to talk about the victim advocate role at arraignment, or do you want me just to kind of keep going through? What's helpful for you?
Joe, can I just ask a question before?
Sure.
Just, you mentioned going through the statute with respect to this, and you mentioned violation of protective orders, which is outlined in the statute. You also mentioned serious domestic violence, which is not outlined in the statute.
Correct.
And I probably asked you this question the last time we met, but I'm not sure. So is that sort of part of a policy from family relations to make that recommendation since it's outside the statute?
Yeah, and I think that we had an actual hearing and trial before Judge Zagaya on this whole issue. Family relations counselors make recommendations. You know, it really is up to the prosecutor and the judge to determine conditions of release, which GPS is one. We are not necessarily recommending this program. We just let individuals know, one, they meet the statutory criteria, they should consider it. And two, there's a really serious domestic, you know, the court or the prosecutor may wish to think about this as a condition of release.
Okay, so it's sounding to me like the serious anything outside of the statutory criteria, which is really a violation of protective order, violation of restraining order, that it's really policy recommendations to bring to the court's attention, and then the court can take it from there.
Or, you know, there's a lot of times where prosecutors will say, this is really serious. How about alert notification GPS? So
Right.
I'm not sure it's always family doing a policy. I think that's the common language that's used. But yeah, we have certain charges that we ask our family relations counselor to consider talking to the prosecutor in the court about the potential of utilizing this for victim safety.
Thank you.
And again, everything is up to the court, right? The judge can determine, even with statutory cases, they can determine what the conditions are, and they don't automatically have to put this on either.
I've had lots of conversations with Judge Zagaya on this back when I ran that office. So yes, understood.
Thank you, Joe. I actually think this would be a good time for Shauna or Andrea, if you want, to talk about maybe what the victim's level of safety is, what you do as an advocate, and how you share that with family relations.
Sure. Andrea, do you want me to kind of give like an overview, and then if you want to jump in with specifics of how it works on the ground, that would be helpful. So yeah, like Joe mentioned, we are heavily involved in the process. We're there to assist the victim through the court process, make the wishes of the victim known to the court, and remind them that any ultimate decisions are up to the judge. So we always use conditional language when talking about the GPS program. We don't make any promises, even if someone is statutorily eligible. So again, as Joe mentioned, the 3 criteria that we look for are a violation of an existing order of protection, whether the victim scores as high risk based on their answers to risk indicator questions that our FEVAs ask, but also based on the DBSIR squared that Family Relations is asking the offender. And of course, whether or not the victim wants to participate, because that's obviously important. If the victim doesn't want to participate, this doesn't really work. So some safety planning that our FEVAs will do with the victim might include keeping the device charged, talking about their willingness to participate and how that will be kept confidential by the family violence victim advocate and Family Relations, but that the defendant may still find out based on their attorney's understanding of the program whether or not they're willing to participate. If the victim wants their address kept confidential, then they'll only receive mobile alerts. That's an option. If the alerts at any time become too frequent, the victim can notify the FEVA at any time so that they can let Family Relations know to either suppress alerts or discontinue participation altogether. We let them know that if they're going to change their phone number or move, so their address changes, they need to let the FEVA know so that they can let Family Relations know. And if a cell phone is a barrier to a victim, the court will provide a cell phone for them so that they can participate in the program. I think those are kind of the overviews, but Andrea, if you want to jump in.
Sure. So I mean, when we're on the ground in the morning of arraignment, I mean, the most important thing for us is we're prioritizing these potential GPS cases. But we also are not going to mention the GPS until Family Relations does their assessment. Because like Shauna said, we use conditional language because it is up to the court ultimately, and it is up to if they meet the criteria of the protective order, the violation of protective order charge, and if they meet the score on the DBSIR squared. So we wait for Family Relations to do their assessment, and if family deems that they have met the criteria, the counselors will let us know that they are potentially GPS eligible, and we are pretty much given the okay to go over the program with a particular client. And then we will call the client and go over the program in addition to our regular arraignment questions. But again, we do not offer the program without knowing that they are potential. And then we also have to go over our risk indicator questions because that's also a criteria. We'll go over the different options when it comes to participating. I personally, like to, warn clients that this is a rigorous program. They're going to get a lot of alerts. Sometimes the alerts can be triggering to victims, knowing that, the offender is around them. Because a mile, I believe with the buffer, it's a mile. So it's especially in New Haven, for example, a lot of things are within that mile, and the person could be nowhere near them or nowhere near their area, completely, somewhere else, but yet within that mile, and that can be very triggering for them, and they're going to get a lot of alerts. Or they could be, within their, daily routine, and because they have to drive through where the defendant lives to go to their job or their child's daycare or something like that, the police may end up meeting them there because it went through the zone. So those are kind of daily life things to consider that they should be aware of, and that they're going to be getting a lot of phone calls from the GPS company. They're going to be getting a lot of calls from Family Relations. So it is something that I think they need to be prepared for. When it comes to their participation being confidential. I always let them know that it's confidential in the sense that I won't tell anybody and family relations won't tell anybody, but everybody's been trained that, you know, if the victim doesn't want to participate in the program, then maybe the judges shouldn't really be ordering it, because then if the victim doesn't want to participate, then there's no one to notify. So I tell my victims that let's operate that the defendant knows, at least about the stationary zones, because there will be, they will be provided maps. While they may not know about the mobile zones, there's no guarantee that their attorney may not tell them. And the language of the mobile area is on the protective order. So again, I don't promise that the offender will not know about their participation. And I always operate on, let's just assume that they know, or eventually they may find out throughout the court process, because everybody is trained that if the program is ordered, it's because the victim wants to participate. And again, the conditional language is incredibly important, because we've had many, many cases that meet the statutory criteria and our judges still haven't issued it. So we then have to safety plan on the back end if the program is not granted.
Andrea, can I ask you a question? How
Yes.
often, and I've heard this with our own staff at the network, how often is having contact information for that victim in a timely manner an issue? Because the judge does want victim input on that before it's initiated. Is that, as we're looking at this section of this model policy, maybe we can kind of see if that's an issue and see if we can correct that?
It can be, because if we don't reach the victim at arraignment, if we don't have a correct phone number, then, the screening process kind of stops there. Because if we don't know if the victim wants to participate or not, the judge is probably not going to order it. So we need to be able to reach the victim. So there are a lot of times where the screening process has stopped because we can't get a hold of the victim. It is written in the policy that if we reach the victim later, after arraignment, they respond to our letter or they get the voicemail a day later and they call us back, that, we can ask that it be imposed on a later date. In my experience, that's kind of been an uphill battle in court to get it ordered post arraignment. So it is vital that we reach these clients, first thing in the morning. And like I said, our office and family relations, because of the process of the install and how long it takes and the window, these cases are prioritized in the morning and we try to reach them, first thing. So we need correct contact information for sure. And if we don't have it, then it's not getting ordered.
There was some legislation last year that actually requires law enforcement to provide information to Family Relations Bill Commission. And in my travels, I find that it's not as well known as it could be. So maybe perhaps this is something that we can consider in enhancing this.
So historically, we have many defendants were placed on our program without victim either wishing to participate or no contact. Law enforcement came to us pretty significantly and said it's a danger to our officers to go to a place where we don't know that victim is there. We've made no contact, especially in some of the more dangerous parts of Connecticut. At 2 in the morning, if the law enforcement goes and knocks on the door and the victim, we don't know if the victim's there or not, it's dangerous. And that was kind of one of the things I know that over the course of the years, law enforcement has said it really is important. If this program is for victim safety, and that's what it's for, that the victim at least be willing to participate. We have to have a contact number so that we know that that person's there, because officers were going into situations where there was a lot more unknowns and a lot more dangerous situations than would have happened if the victim was there. So we changed our policy around that right after COVID. But really when it went statewide, that, if a victim chooses not to participate, then when we give that information to the judge has every opportunity to order this if a victim doesn't wish to participate or we can't contact the victim. I think one of the things we talked about from a law enforcement perspective is the safety of the officer. And going into a situation where there's more danger because they don't know who's at 100 Main Street. If the victim might have moved, the victim might have, doesn't want the police there. There's other individuals in the home that might not want police officers to be knocking on their door. And that's kind of why we shifted our focus on that.
Excellent. I think that this would be a good point to ask Captain Maynard to talk about law enforcement, what those alerts come in, what they look like. And then we'll circle back to Safe Connect and what Safe Connect is passing along, how that works. So if you could do that, that'd be great.
Good morning. I'd like to start by saying thank you to Joe DeTuno for a lot of the efforts in the program, but also the training that law enforcement has received on an annual basis. We are receiving the training at the legislative updates known as the Bailey Seminar for all chiefs of police. And then there's been several training opportunities at the Training Academy in Meriden for law enforcement to learn this. When we talk about domestic violence response as a whole, because that's also what we're talking about when we're talking about this GPS and alert notification. Any domestic violence call, to break it down in very general and broad terms, when we receive response as law enforcement, we're going to proceed to the scene. When we go there, we're going to go there knowing that there's a priority of life. And what we mean by that is we're going to make sure that the scene is safe. So we're going to separate parties as we need to. And once we know that that's taken care of, we're going to conduct a preliminary investigation, which essentially determines has a crime even occurred, and then do we have probable cause to make an arrest. Adding in the GPS and alert notification is really a lot of the same pieces, because what we're responding to and the purpose of this program, as it was referenced and even by Joe, is really the priority and the safety of the victim, right? So no different than any call, when we receive an alert or a notification that there's been some sort of, because there are different methods that this could come in. So whether it's an exclusion zone, whether it's the mobile zone, maybe it's a device tampering or lost communication, regardless, law enforcement response is to proceed to the victim and ensure that that victim is safe and secure. The first thing we're going to do is try and make contact with that victim. And that's what we need to do, ensure that everything's okay. So while we're doing that, we determine that they are safe. We're also going to be trying to make contact with the person that they're not supposed to have contact with and determine was there a violation. While we're doing that, we're going to ensure that the victim is safe. So everything we talked about with safety plans, we're going to go over that safety plan with the victim. Just because there wasn't a violation at that moment, it doesn't mean that there couldn't be a violation in the near future or even following, whether it be that day, that night. We're going to ensure that the victim knows that they have a place to go. Who are they contacting? Do they feel safe in their current environment? And if we determine, obviously through that there was a violation, if we have speedy information, we're going to make an arrest on site. If we don't, we're going to follow up with a warrant. And it's going to be similar to domestic violence, where we're pushing that through to remove any sort of period of time between the offense and the arrest. So it's really very similar to pretty much all of the domestic violence calls. There is a script that is received as far as what's being said, as far as notifications that are going out to the victim, what's also being told to law enforcement as far as what sort of notification we're getting. And then if we have any questions, there are phone numbers available. So for Joe and over at Family Services, so that we can follow up as needed.
Did you want to address the different types of alerts that law enforcement receives, and maybe then talk about what alerts law enforcement does not receive?
Yeah. So family relations counselors, with the help of the victim advocate at the court level, court business, we triage all the alerts. So as an example, if I'm on the program and I am not supposed to go to this building and I end up being here, there will be an alert. And when that alert happens, Sentinel Offender Services has a protocol where they're sending a text to the victim. They're following up with the victim, letting that person know that the person that shouldn't be where they are is close to them. They have a live monitoring center person talk to the victim, let them know exactly what's going on. And then at the same time, Sentinel is calling dispatch, and they tell the dispatcher exactly what's going on. If there's a part of the script which we hand out to law enforcement during our training sessions, where they have the ability to continue to talk to Sentinel. They can stay on the line with them while they do their investigation. if they break contact with Sentinel, that is where sometimes there's a challenge. But for the most part, we're giving law enforcement the information that we believe is necessary for them to, one, make the victim safe, which is the priority of the program. But if they wanted to make contact with the defendant, we give them their last known point position. If a law enforcement person wants to actually go after the person in real time, Sentinel can stay on the phone. That just doesn't happen, but they can. We've had some scenarios where it's a situation where the victim was in peril and they switched to like a real-time monitoring with law enforcement, and they give like minute to minute, like where that defendant is. But again, that's in a very, like, in 15 years, it's happened like once or twice. Usually what happens is that an alert happens, family relations counselors after the fact are looking at what happened. They triage the alert. They make sure that whatever was alleged, strap tamper, stationary zone violation, mobile zone violation, that while working with Sentinel, that was a true period of noncompliance. It is at that time where we will go to the prosecutor and let them know exactly what's happening, and they decide whether to bring that defendant back to court. Usually law enforcement, if they have connections already, will call family services. But for the most part, given the statewide nature of this, they're usually calling the prosecutor and saying, hey, we want to do a warrant, or we want to do an investigation. And then, how do we get the points necessary to do that? And that's really usually how it happens. And it's more after the fact than actually in that time, unless that defendant is actually caught at the location, in our experience.
Joe, for the purposes of some of our committee members that don't know this, could you just go over the different types of alerts?
Sure.
And where those alerts would go?
Sure. So I think there's three major alerts that law enforcement really is called to. The first is a stationary zone violation. A stationary zone violation is a known address of the victim, usually their residence. The defendant knows exactly where not to go. They're provided a map by family services of the streets that encompass 2,500 feet around that location. The defendant is told exactly where not to go. We inquire of that person at the time of installation. Is there anything in that zone that you would need to access? Medical doctor, mother, relatives. Is there any work? Is there anything that would that defendant would need to actually go there for a legitimate purpose? We try to eliminate all those barriers. But a stationary zone is 2,500 feet around a fixed address. There's also mobile zones. If a victim chooses to fully participate, if they have a fully charged device, there's a 1,000-foot bubble that is around that person at all times. And as they move in the community, there's a zone around that person. Unlike the stationary zone, typically the defendant doesn't know where the victim is. So for law enforcement purposes, those mobile zone violations somewhat are problematic because a lot of them happen on the highway. They just drive past each other, and there's no ill will. One of the roles of a family relations counselor is when they're triaging mobile zone alerts, is to find patterns of stalking. Usually it's just two people moving in the community. And, again, our real role in that is to make sure the victim, as they are able to move in the community, know that the defendant is near them. And if they happen to be in a close proximity, the victim can make choice. But there's also times where the defendant has been following the victim too. And all that information goes to the prosecutor if it is something that we find to be significant noncompliance. The majority of the times where we're really concerned are strap tampers, or device tampers, where the defendant, takes the strap off, removes the device. Those are times where we're immediately contacting the prosecutor. But in those situations, law enforcement is asked to go to the defendant and the victim during strap tampers. But I think that, in terms of program operation, the stationary zone is very cut and dry. A lot of times the defendant will come and say, I needed a ride to work, and I told the person, don't go on Main Street, and they just drove on Main Street. It wasn't anything that was problematic. We still bring that to the prosecutor, but usually the prosecutor will say, okay, was the victim contacted? No. All right, they're not going to bring that person to court. There are times where people just willfully are non-compliant and they don't care. Those are the situations where we truly ask the prosecutor to bring the matter to court. They usually do. And then we inform counsel and they have a hearing, and it's then up to the judge whether bonds are raised. At the same time, the police can do warrants for those types of situations too. But I think suffice it to say, for me, in my experience, the vast majority of consequences for this comes from a prosecutorial perspective rather than a law enforcement perspective. The prosecutors are the ones that are going to raise their bond. They can ask for new charges. They can ask the police for a warrant. So that's typically how it goes. Other than that, I mean, I think that strap tampers, there are the times where, where if it's a willful thing, that those bonds are being raised pretty most of the time. I think it's really good to have a family relations counselor who has experience in the program really triage that alert at the court level to make sure that it's legitimate. We don't want someone to lose their liberty over something that is a mistake. So we really do spend a lot of time with the victim advocate, making sure the victim hasn't been contacted, but we really look at what situations would go to a prosecutor and to a judge. And usually they're for serious non-compliance or for somebody who willfully just isn't going to be compliant and they choose to do whatever they want.
Joe, there's also two other alerts, which would be the low battery and the buffer zone. Do those go to family relations and then the
Yep.
victim's contacted, or is that sentinel right to the victim?
No, I mean, so a low battery alert for the defendant is really for us as family relations counselors to let the person know to charge. That would never go to law enforcement ever. It is just us telling the defendant that they have to do what they need to do to charge the device. If that device goes is dead, then we go right to the prosecutor. We want to make sure that the individuals that should be monitored in the community are. But again, that's really the kind of the person that isn't going to be compliant. But we do a bunch of stuff to get, Sentinel does things to get the person in compliance. We do as family relations, we do a lot to get the person in compliance. So low batteries would never go to law enforcement.
But it would go to the victim, correct?
Low batteries would.
Okay.
Only if the device dies. But again, I think what we would be talking to the victim advocate about is the non-compliance, and we would have discussion that, hey, this defendant isn't really kind of with the program. We would want the victim advocate to know so the victim is aware that kind of there's some issues going on. But until that battery dies, that's just us trying to get the person back into compliance. So that was low battery. And buffer zones. Buffer zone is really just another footage around a stationary or mobile exclusion zone, which is a pre-alert alert only for the victim. Law enforcement would never get contacted for a buffer zone violation. I think Andrea and Shauna might agree with me, is that the buffer zones are the majority of the alerts, and that really makes victims kind of sometimes hesitant to remain on the program, because if you live in close proximity, if you're in Hartford as an example, 2,500 feet plus a buffer zone of it's a half a mile. And people are just doing their thing in the community, there's going to be a lot more buffer zone alerts than anything else. We're really sensitive to alert fatigue by a victim, but we're also very sensitive to the idea of law enforcement going to non-emergencies. And a lot of the work that we do at administration is getting calls from local law enforcement and really talking about individual people who are creating resource issues and what we can do to mitigate that. And we really take that very seriously, and we will meet with the defendant. We'll try to figure out ways for that person not to have mobile zone violations, especially if there's known patterns, right? If I might have a mobile zone and I know that on a Tuesday night, everyone goes to this place and they all go. And I don't necessarily know if the victim's going that day or not, but I'm a defendant and I want to go to whatever it is. And I go, and there's every Tuesday night, law enforcement are like, Joe, every Tuesday night we're sending people to this. Can you do something about it? We'll have conversation with the defendant to say, what are you doing on Tuesday night? You're not doing that anymore. And just to let them know, not to give them information about potentially where the victim is, but again, I think one of the key things here is that these are not cases that police officers aren't aware of. right? When you get to the level of being on this program, I'm assuming that law enforcement has spent a lot of time with these individuals over the course of their time. And we just want to make sure that the victim can move in the community as that person sees fit without getting these alerts. But we're very sensitive to law enforcement having to continue to go. And we try to do whatever we can to shift those kind of routines that people are accustomed to.
Joe, other than low battery, does the defendant get noticed for any violations so that they could, in theory, moderate their behavior?
Not in real time.
Yeah.
So stationary zones, they're cut and dry. You're not supposed to go here. That's usually just a conversation, usually at court. One of the things that is different, so we always talk about levels of consequences. Coming to court and talking to family relations, although that's not going to lead to loss of liberty, but that's a consequence, right? You're bringing them in, we're having conversation with them. In terms of other discussions with the defendant, yeah, I mean, but not in real time. It's not like we can talk through the device, but we don't. One of the things that mobile exclusion zones, although kind of problematic, are really our discussion with the victim to let them know where that defendant is. If I always use this, I'm a Patriot season ticket holder, and I use this example. If I go to the Patriot game and the victim chooses to go as well, I'm not doing anything wrong. I'm going to the Patriot game, but we're in that zone and the victim is there. And as long as Sentinel talks to that victim and Foxborough Police goes to make sure that person's right, that victim's going to have choice. I would never want to say to the defendant, you have to leave Gillette Stadium, because why? If I'm going to do something bad, now I know the victim's there. And I know that, okay, well, I know that there's only one way out of Gillette Stadium is Route 1. I know that victim at some point during the next hours is going to leave Gillette Stadium, going to Connecticut. I'm going to wait on the side of the road. You know, we don't want to do that either. So again, the mobile zones and everything that we're doing is really to make sure that the victim knows the defendant is near you and act your safety plan. And law enforcement helps by making sure that that victim is safe by going to that person and doing the program. Does that help? Did I answer that right?
While we're talking about alerts, I wanted, if Rosario could chime in on Safe Connect's role in our communications with victims when we have alerts.
Definitely. So for Safe Connect, as I always tell the coordinators, which are the advocates that pick up the phone 24/7, I let them know, you know, we're not the first line of defense when it comes to the alerts. Usually our purpose is to make sure that the victim is safe and that they're connected to services and further safety planning. So usually, depending on the type of alert, we have certain protocols depending on the event to when we're going to follow up with the victim. And so once we do, depending on if this is a first-time victim that we're reaching out to, we have a different script to the ones that we receive pretty often, and we kind of get to know them already and they know us. So we're pretty much just checking in, making sure, did you receive the alert? Did anyone check in with you? Did they provide the information for you? Do you want to further discuss services that are provided by your local domestic violence agency? You want us to do a referral for you, provide an intake? Do you need information to any other service need, even if our programs are not the ones who can provide that service? So we'll provide them information to other agencies and resources as well. Connect them and advocate for them in a moment if we need to. And then we pretty much do that every single time we receive an alert for them. And again, it just really depends on the alert. And then depending on the outcome of the entire conversation with each client, we email the appropriate court office at CVA to let them know how the conversation went, to let them know of any concerns or issues that came up with the specific alert or outcome and conversation with the client. Sometimes we often do like suggestions based on what the client stated. And then just kind of keep that open line of communication between the FBVA, us, and the victim as well.
Thank you. So just out of curiosity, if a victim does not want to participate in the program, but is working with the FBVA, if you, obviously would have the stationary zone would be, if you've got that, would you try to make attempt to call that victim if the victim's choosing not to participate in carrying of the device or not participating in alerts altogether?
Yeah, so we're pretty honest with all victims, explaining the protocol that we have to put in place and always reinforcing the fact that it's due to their safety that we may follow up with them. However, depending on the victim, we have sort of readjusted the way that we're reaching out to them. So with Safe Connections, we do have the capability of also texting clients or emailing clients. Most of them, because they get overwhelmed with the amount of phone calls that they receive, some of them have opted to only receive text messages as a checkup. And so what we basically tell them is, we're okay with doing that as long as we know that you are texting us back and responding to that. We're making sure that you are safe and there's nothing else that you need further. But obviously if something does come up and they always have our phone number to reach us 24/7. And then if we don't receive a text message back or an email back at a certain time, then we are going to call them and attempt that call. We do 2 attempts with them. So in the first attempt, we usually leave them some type of voicemail or message saying to call us back because we're trying to reach them, just to check in on them. And then we do a second attempt. And whether we reach out to them or not, we then send that information to the FEVAs. And so we do get a lot of clients who do tell us that because they're getting overwhelmed with the amount of notifications that they're getting, that they no longer want to participate in the program. And so that information we put in the email for the FEVAs to kind of take a note of that as well.
Thank you. I actually really appreciate the point that Joe brought up that is probably a challenge for law enforcement. If you have a victim that doesn't want to participate, regardless of the safety of the neighborhood, if, law enforcement's having this mentality that this program's about safety first, what if they can't find that victim to ensure that they're safe?
Well, I mean, our hope is that Sentinel would have made contact with them, and because a lot of times law enforcement, the dispatcher will ask, has the victim been contacted, just so that, and they tend to have the information about victim contact too. I mean, again, they have those abilities to contact people, and so a lot of times it helps law enforcement know that, we just talked to the victim, she's at 100 Main Street and she's going to be waiting, by the door, whatever the example is. It helps law enforcement know who they're looking for. There's no photos of defendants or victims unless they have it in their system. So, I'm really glad that, we're having this discussion, because I think Safe Connect, which has been a really recent addition to our program in terms of safety net, especially 24/7 weekends, nights, to be able to have contact with someone like Safe Connect or an AIDS, the hotline is really helpful to victims as we move through this. It really was, CCADV brought that to our attention as something that they would have liked to see as an enhancement as we move forward statewide. And I couldn't agree more that it was a great addition to what we're trying to accomplish.
So Joe, if a victim chooses to opt out, I don't want to be part of the program at all. If there is a stationary zone in alert, Sentinel will still call them?
So if a victim doesn't wish to carry the mobile device anymore, I think that's really what they're talking about. It's more, and they might just want nothing to do with the program, but usually what we've experienced is that the mobile device is the thing that really creates most of the alerts, buffer, and exclusion. And most of the time the victim is going to bring the device back and only want the stationary. If a victim totally doesn't want to participate at the next court date, we'll let the prosecutor in court know, and they'll modify the protective order so that there's something that doesn't exist, right? And usually the offender will be taken off the program. If a judge, at that point, typically what a judge might do is shift them over to IPS GPS, which is the probation GPS, and not have the person be on our program if the judge wants that as a continued condition of monitoring in the community. So when we talk about once a victim indicates to us that they no longer wish to participate, and Andrea probably has more experience with this than I, but it's usually the mobile devices. They don't want that. And once they bring in their equipment, there's no more mobile zones. So Andrea, you want to help me on that?
Yeah, sure. So the mobile device is definitely the biggest piece because it's definitely the piece that contributes to the most alerts, especially the buffer, because the exclusion and the buffer, like I said, it equals an entire mile. So when you're in, a city that it covers a lot of area. So a lot of victims, going through their daily lives kind of realize how many alerts they're getting. And then they're getting the calls from Sentinel, then they're getting the calls from Safe Connect. And then there are times the police are showing up and Family Relations is calling them, sometimes depending on the alert and the email that I get from Safe Connect, my staff could be following up and they can get very overwhelmed and they may not want to participate in the program at all. So when we get clients, who call and tell us that we, let them know that we can take them a step down on their participation. And they can turn in the mobile device and still have the stationary zones before, we tell the court, they don't want to participate at all. And then a lot of times they'll opt for that as opposed to asking for the program to be removed completely because the biggest piece is the mobile. But then we also have other people who don't want it at all anymore. And if then that's the case, then we'll notify Family Relations, we'll notify the prosecutor and the court for the next court date, and then the offender will be removed from the program altogether. But we will try and start with just the mobile device if they truly don't want it anymore because of the excess and alerts. And a lot of it is really the buffer zone. So it's not even the stuff that go to the police officer, it's the buffer of just kind of the FYI that he's in the area. And like I said, that could be pretty triggering because that person could be, 2 streets away, minding their own business, going somewhere else. And then, the victim's just going to the grocery store and, it could be pretty bothersome and triggering knowing that they are that close, that otherwise without the device, they would not have known that. And sometimes, some victims, like knowing exactly where the person is and they feel better knowing it. And other people are like, you know what, I would prefer not to know, his every move and I'm done. I don't want this anymore. So we kind of have both sides of the coin, but we will, talk to victims about, you don't have to go off the program completely. We could take a step down before we tell the court you don't want to participate at all.
And I think the most important thing is the triage that we do in working with the victim advocate to try to find solutions. If there's a lot of buffer zone alerts, why is that? They live by a highway. We can shrink the buffer zone. We can move the zone a little bit so that we take those from too many to just a few. I mean, there's a lot of really creative things that we can do to make sure that the victim still can have the level of protection or safety that that person wishes, even with some environmental barriers. I think the biggest barrier is people live close to proximity. And there's just there's not a lot we can do, especially if they're living near major highways. So I think that we spend a lot of time making sure that this program can fit within, the victim and the defendant's kind of world, knowing that we want to make sure law enforcement isn't going to non-emergent calls.
Hey, I just want to thank you, Joe. Thank you, Captain Maynard. Thank you, Rosario, Andrea, and Shauna. I would like to open this time up now if anybody has any questions on the information that's been shared with us today.
Joe, I've got a couple questions for you, and maybe I'll follow up with an email. But the first one is now, and I could follow up with an email with the other ones, is when we talk about expanded use of this data, how long is the GPS data being saved and who's in control of that?
It's Sentinel Offender Services, and I think they're, don't hold me this, I think it's like 3 years. But we never, I'm the person that releases the points since 2010.
Mm-hmm.
I think that we've gotten probably 6 requests from the court for trials. And usually it's not old data, right? These are for pending cases.
Okay.
And usually it is, if you're going to have a trial and you're going to say someone got arrested for violation, Sentinel Offender Services comes to testify about, you're going to ask questions about whether it was a legitimate alert, what kind of equipment do you use, and all those things.
Yeah.
the points are the points. I mean, I think that they're plotted points. There's accuracy thresholds on them.
I'm thinking of like of a scenario of perhaps a crime occurs on some day and the police would like to see where a suspect was located.
That would always come through me, and the only way our points can be given to law enforcement is if it is an active domestic with the two individuals, that defendant and that victim. We wouldn't be giving points for just general crimes.
When they
especially
serve
if
you
it-
with a search warrant.
But that's up to the judge, right?
Okay, all right. I just
wouldn't
want,
be for me.
okay.
But I don't think that's ever happened where, that has occurred.
Okay.
I would imagine that every public defender, at least that I've worked with, would know how to address that, as well as probably everyone in the private bar.
Yeah.
Those would be situations where I would be called to testify in Sentinel. That's not ever happened.
Okay.
Um,
It just, if I could just ask one more
Sure.
in its general, and I know when this was first rolled out in Meriden that even the police were troubled by this 1,000-foot mobile zone, just because of the congestion of certain areas.
Great.
Is somebody keeping like stats for this type of thing? Like if there's a mobile zone violation and it's really not a violation, like,
Well, I mean, I think what we have to differentiate whether the devices were in close contact with each other versus whether it was an additional crime.
right.
And whether it was something that the court prosecuted or,
Okay.
the judge raised bonds on.
Yeah.
I think that every law enforcement agency, when I present, is assuming that there's going to be thousands of people on the device. There's probably 15 people in Meriden.
Yeah.
So it isn't it's daunting when one person creates a havoc, right, and drives around, and there's we had a situation in Danbury where an Uber driver thought that while they were working, they could go wherever they wanted. But we addressed that, right?
Yeah.
So yeah, I think that people just assume that every person is going to have this device and there's going to be 100,000 calls. That's
Right.
just not accurate. So
Okay.
I think what happens is that there's a learning curve that happens and there's a lot of unrest, and then they see that it isn't problematic, and that when there are problems, they're able to contact someone from the court, and we truly make good faith efforts to fix the issue. Sometimes it's not fixable, right? But at least we have points of contact. I know I've spoken to many law enforcement individuals over time. Kevin, who oversees the program now, does the same. We just got a call a couple of days ago. It really boils down to one person creating some issues for law enforcement. I think that once people understand that this is not as impactful as they imagine it to be, and they're not just, the court's not saying we don't care. I think that it levels off.
Yeah.
And there might be a month or two where there's no problems, and then one defendant all of a sudden is problematic, and we have good communication. And I think there's an avenue for discussion on it. And whether that law enforcement person has to call the prosecutor's office, or we end up getting with that individual and we kind of explain the program, because sometimes there's some misconceptions about what we do. And once you clarify that helps. And then I think good faith efforts to remove barriers, we can mitigate a significant amount. We might not be able to completely address it, but I think that helps very much for law enforcement.
Thank you.
Does anyone else have any questions for any of our presenters?
I don't have a question, but I want to make an observation as a survivor representative that I find this all truly amazing. It was not available when I went through my experiences. I wish it had been. And I just, I want to recognize or thank or praise everybody who's been involved in putting this together on behalf of survivors and victims, because I think it's a step forward, and I think it makes a lot of people feel safe and maybe prevents a lot of unnecessary trauma. So that's my way of saying thank you. That's all I wanted.
Thank you, Nancy. Thank you for being here. Okay, it's hearing that there are no questions, I think what I want to just kind of say to the group is that we are going to have to make some adjustments to the GPS section related to law enforcement and their response to these alerts. It is on page 20, so maybe we could all take until our next meeting, take a look at what's there. It does need to be updated, and maybe we could talk about if there's a way that we can make this really clear, so it's kind of like a universal response across the state if we're having issues. So that's kind of where we're headed with that. So I appreciate everyone's participation in helping educate some people that requested to learn about this. Thank you.
Then I will take the ball back again, and I will also offer that note of gratitude to all of the speakers that were able to share their expertise with us this morning to take a complex area and make it digestible for those of us that either aren't familiar with it or even in the case of myself, aren't working with it every single day to that granular a level that we heard about this morning. So our thanks to all of them. I will also take the liberty as we, begin to wrap up, specifically on the GPS portion of the discussion. I took the liberty of just jotting some notes, and they echo what my co-chair shared a moment ago. I took some notes as the speakers were speaking. On the one hand, we may have, and I think we do, a policy issue to be addressed. Our policy appears not to have caught up with the current state of affairs. So that is a reasonable bar for us to tackle as a subcommittee as we work into the early part of 26 and report back to the larger group. I know that there was also, and this is sort of option 2 or the right-hand fork in the road, there was also some initial chatter, some initial discussion within the group about whether or not we could or wanted to or should even begin to go down the road of considering any sort of expansion to what GPS is, what GPS monitoring is, as part of a larger domestic violence working group recommendation. But with that, obviously, comes, and I can identify at least 3, is there the possibility that we would need statutory change? And that's something this group could work toward, but it's a much heavier lift. Similarly, is anything that we're thinking about something that would require a funding source, another high bar? And then finally, as part of 1 and 2, or 2A and 2B, whatever I'm up to now, are there constitutional or legal concerns that are going to walk hand in hand with any recommendations that we might be making as to the expanded use of GPS in domestic violence cases, or potentially anything even broader than that? So those are high bar thoughts that may or may not be part of future discussions, but we all do need to be aware that if we do ever seek to advance what this committee's goals are, what our objectives are, statutes and funding and legal concerns have to be part of those discussions. At a minimum, we can certainly work towards syncing up the policy with what the current statute and funding and legal process happens to be. So I would put that bow on our time together to the extent that anyone finds it helpful. I found it helpful for myself to think about where we were going to go. We are just over the 1 hour mark, but I would certainly open the floor to anyone that wished to raise any items under other business, Roman numeral 5. I do not have anything specifically to raise under that subcategory. The floor is open for anyone on other business items. Being happy to see that at 12:06 in the afternoon, I will then take the liberty of moving on. Your Roman numeral 6 has an indication of the next subcommittee meeting date of 12/16. I'm going to put a question. I'm going to take the liberty of putting a question mark next to that. I can tell you that that would be a conflict for me, and I'm not, and not that my presence is necessarily a prerequisite to the group meeting, but we will, to the extent you have 12/16 on your calendars, please hold it. There's the possibility of a meeting on that date. or there's a possibility of a different date, or perhaps even the possibility of a cancellation of 12/16. I do believe that we have the full committee that is scheduled to meet the next day, 12/17. So we certainly would be very happy to have a robust attendance from this working group for the larger group on 12/17. Please stand by for further on 12/16. Last call from anyone on anything. I would entertain a motion to adjourn.
Motion, Maynard.
All in favor? Aye. Any opposed? Thank you all. We will look forward to seeing you in the month of December.
Thank you.